How do common law trademark rights affect a cease and desist letter? Imagine you see someone using a name or logo that looks just like yours in your local area. You might wonder if you can do something about it. That's where common law trademark rights come into play. These rights are created simply by using a mark in commerce, not by registering it officially. When a business uses a distinctive name, logo, or slogan in a specific place and customers recognize it, they gain certain rights in that region. If you believe someone is infringing on your common law rights, you can send a cease and desist letter. This letter is a formal request asking the infringing party to stop using your mark. But how do your rights influence this letter? Well, first, you need to prove that you were the first to use the mark in the area where the infringement is happening. Your rights are limited to the geographic zone where your mark is recognized by consumers. If the other person is outside that area, your rights might not cover them, and the letter might have less impact. Next, you need to show that the other party's use of the mark could confuse customers. This is a key part of any trademark claim, whether based on common law or federal registration. Your cease and desist letter should include evidence of your use, like sales receipts or advertisements, to support your claim. If you can demonstrate that your mark has been used first and is recognized locally, your letter has a stronger chance of stopping the infringement. It's also important to remember that common law rights are not listed in a central database. The infringing party might not even know you have rights unless you clearly explain your geographic scope and provide proof of your use. This can make it harder to prove willful infringement, but it doesn't mean you can't enforce your rights. Your letter should clearly state where your rights apply and include evidence of your use in that area. In many cases, a well-crafted cease and desist letter based on common law rights can be effective for stopping local infringement. If the infringer is using your mark across the country or has a federally registered trademark, you might need to consider legal action like filing a lawsuit. Overall, your common law rights can support your case, but the strength of your cease and desist letter depends on solid evidence, clear geographic boundaries, and the likelihood of customer confusion. Always keep good records of your use and consult with a legal professional to make sure your letter is as effective as possible.